Okay, so I assume screen sharing is kind of working. You can see Ray. Awesome, good. So yes, our team, which is Ray, Sergios, Chi, and myself, decided to look at challenge 4, which was about the Renting Homes Wales Act 2016, and what we could do to kind of make it more accessible to people. So I'll kind of launch into our problem and then hand over to others as we go to get into our solution. So the background, what was the problem? We took as our kind of problem person or troubled user, the tenant, who is trying to work out what their rights and obligations are in a given tenancy context. And started thinking about, well, where would they look to find out in any given situation what their rights and entitlements were under their tenancy? And while a lot of the focus in discussion at this hackathon so far has been about legislation, actually, it's probably going to be the agreement between the landlord and the tenant. Their lease agreement is really what's going to embody most of their legal rights and obligations. But the lease agreement itself is complicated by the fact that other people have a hand in what the lease says. So we have the Welsh Assembly, representing probably a more diverse way than is warranted, coming along with the Renting Homes Wales Act, which incorporates into a lease fundamental provisions and supplementary provisions. So terms which, even if they're not expressed necessarily in the lease agreement, might be read into it and bulk out its content. And then if you're the tenant, how do you know those terms are there? And then the Renting with Homes Wales Act further allows modification of the lease agreement because it allows Welsh ministers to come along by regulations and inject yet more content into that lease agreement. So while the lease that the tenant has in his hand, a single document or sheet of paper, setting out rights, might not be the whole story. And one of the challenges is, how can we help the tenant to see the whole story in their case? So the situation gets quite complicated. As I mentioned, there's the Renting Homes Wales Act incorporates things called fundamental provisions into lease agreements, but we can further subdivide these because some of the fundamental provisions the Act lays down can be excluded explicitly by an agreement between the parties in the lease. So it might say, you know, this fundamental term isn't here. Some of the fundamental provisions, they can't be excluded, but they can be expressed in a slightly modified form. Some of the fundamental provisions can neither be excluded nor modified. And some of them, once they're included, so you've got an option whether or not to include them or not, but if they're included, some of them are subject to restrictions on how far they can thereafter be varied. So again, what your lease purports to say might not be quite right, depending on the extent to which you can depart from the fundamental provisions. And then, in addition to the fundamental provisions, as I mentioned, we have the Welsh Government, who by regulations can inject supplementary provisions, again, things that will be incorporated unless the parties have expressly agreed to oust them, by and large. And which supplementary fundamental provisions get injected into your contract depends on what kind of lease you have. And that in itself can be quite a complicated proposition. The Renting Homes Wales Act only applies to occupation contracts as defined in Section 7. Presumably there's another set of rules or many other sets of rules sitting off to the side of that for things that aren't occupation contracts. But so you have to apply Section 7 of the Act to test whether or not what you have is an occupation contract, which sets various criteria. Occupation contracts then subdivide into secure contracts and standard contracts. Standard contracts then subdivide into fixed term contracts and periodic standard contracts. Periodic standard contracts can further subdivide into introductory standard contracts and prohibited standard contracts, and then the category that's in the middle. And further kind of qualifying or altering whatever the nature of your contract might be, are the answers to questions like, is it a sublease or not a sublease? And is the landlord a private landlord, or I'm going to say not a private landlord. The way the Act defines it is the other way around, but broadly it means a sort of social landlord, charity, a housing association, whatever it might be. And the answers to all of those things will impact which of the Act's provisions, which of the regulations are going to operate in respect of your lease. Just to further complicate things, and a kind of Welsh reference, this all travels through time and space as well. There's a temporal dimension to what your lease's terms might be, because you can have regulations coming along, as has happened already. So we've got the Renting with Homes Wales Act fundamental provisions regulations for housing associations. Now, these regulations say that things that would be a fundamental provision in other contexts aren't fundamental provisions in the case of a housing association lease. So where your landlord is a housing association. And that, again, the temporal aspect to that is that I'm not yet clear, because this Act isn't commenced. Presumably, if your lease was formed before new regulations came along and said something isn't a fundamental provision, if you already had a lease, that wouldn't retroactively change the character of your lease. But perhaps it might. So there's all of that complexity that needs to be worked in. Just because you've established what your lease's terms were on day one, having worked your way through all this legislation, there is the potential for regulations to come along and unbalance things, change things later. And as well as changes to the law that underlies what the content of your lease is, there could also be fact pattern changes that can change it. So, for example, Section 233 of the Act, an agreement, a tenancy, isn't an occupation contract in the meaning of the Act, and called nothing the Act says matters if it's not an occupation contract, if the only tenant or the eldest tenant is under 18. But then when they turn 18, suddenly it can change into an occupation contract, and all the Act's provisions will click in and bite. So changes in facts as well as changes in law can again alter the analysis of what your lease document is, in the sort of abstract sense of it. So the challenge, and this sort of brings us back to Jeremy Bentham that Fred Schauer was talking about at the start of the week. Bentham said that the desirable object of the laws in regard to style is every moment in which they ought to influence the conduct of a citizen. He can have presented to his mind an exact idea of the will of the legislator in this respect. The challenge is, the law says lots of things very properly. The Renting with Homes Wales Act covers a broad range of different tenancy situations and scenarios. The challenge is, can we use the technology to winnow down all the things it's saying about all the different scenarios, so that a tenant in a given situation can understand what their personal rights and obligations are, what the content of their particular lease is. And that is where I will pass over to Sergios to discuss kind of one particular aspect of that challenge that we homed in on.
As you could see, navigating through the Act can be quite. So we decided, for the purposes of this demo, to focus on a more narrow area, on the termination of the contracts, which causes a lot of confusion and problems usually to people. And even narrower, we decided to focus on the process of termination of the periodic standard contracts, which are in the provisions of Chapter 9, in Part 9 and Chapter 5. And most of them are fundamental provisions that are not any a deviation is not allowed, and they have to be incorporated in the so they make a good example to test out how our solution could work. Can you please go to the next slide? So yeah, in the articles 168, 183, the process of terminating periodic standard contract is described, and this process varies, namely the legal position of the person terminating the contract, if they are the contract holder or the landlord, whether it's the first occupation or a subsequent one, whether this will be the first notice given in this occupation, whether it falls under the Schedule A, and last but not least, whether and when the contract holder gave opposition of the dwelling. So the articles are not really straightforward, and there's a lot of variation of processes and eligibility periods. If you could please turn to the next slide. As an example, in case the landlord is looking to terminate one of their contracts, they need to give notice, must be at least 6 months before the date specified as the termination date. However, if this is not the first notice they give, they must wait for at least 6 months before giving a subsequent notice. Also, during the first 6 months of the occupation, a landlord may not give notice, and this was not enough. In case the contract falls under Schedule 8A, the minimum notice period is not 6 months, but is 2 months instead. From this example, you can see that understanding your rights and obligations can quickly become confusing and complex. And considering this is only a small part of the Act, when combined with all the other rules and their situational variations, we thought that an application that would facilitate understanding and interacting with the law would go a long way in benefiting the people engaging in these lease contracts. And to go one step further, we thought of personalizing this interaction to a contract level, where instead of looking at the Act itself, one would be able to check if the particular contract is lawful or if there are any problematic clauses or areas. We did this because we thought that this is a good way of understanding helping the people understand how the law works and how it applies in their case, but also a quick, easy, and cost-effective way to do a first check of the contract you have or are about to sign, and this will potentially save you from a problematic future situation. I'm going to pass to explain a little bit better what there is in markets up to now.
All right, so before we dove into designing our own solution, the first thing we wanted to do was kind of take a look at the existing landscape of solutions that exist out there for this sort of problem. The problem being analyzing a contract, kind of assisting someone through understanding their lease agreement and identifying what parts of that legislation, what parts of those provisions are relevant to them and their rights kind of thereof. And we did this really for two reasons. One was to try and identify a market gap. So doing a little bit of a market gap analysis to kind of see which demographics are not being kind of serviced by the existing solutions. And the other reason as well was because we didn't really want to reinvent the wheel. Seeing what other products exist out there would give us a kind of breadcrumb map towards whatever was feasible with existing technology and has been road tested in practice. So the good news for us, but not the good news for someone trying to understand their lease agreement, we did identify what we saw to be as a market gap. You can see from the diagram on the PowerPoint that in terms of automated solutions, so kind of assistive tools that would do some amount of that analysis for you. There are a lot of solutions that exist in sort of the corporate space. Now, these aren't lease specific. These are more tools that fit amongst like contract lifecycle management and portfolio risk management. So tools like Kira and Ibravia that can keep track of like massive business scope contracts across a variety of topics, and keep track of entities and key data and definitions throughout that. And even from a more labor intensive, less automated perspective, corporations are kind of better served for this in this sort of area. You have a lot of drafting assistive tools and plugins, as well as, of course, corporate law firms, which are kept on book and help manage this for corporations. For individuals, there are tools out there that can be helpful, but they are, from what we identified, more, again, labor intensive on the part of the individual. So you can find things like checklists and guides, but really you're kind of at the mercy of WikiHow and Google search, trying to figure out which provisions apply to you. There isn't a lot of automated support that can kind of take you from the point of having your lease contract to fully understanding your position. And for laymen like me who don't understand legal terminology, trying to use one of these guides to understand my own contracts, I know from personal experience, is limiting. And you kind of rely on sending it off to your dad or your mum and hoping they understand the contract and they can give you the A-OK on whether or not you should sign it. So on one hand, very positive, we identified this gap for our solution. There was some area that was being underserviced, and we could kind of target. More positively, the fact that these tools do exist for corporations gave us a kind of hint that there is the underpinning technology out there that can do things like comb through contracts and pick out key entities and do the kind of analysis that would be required for a personal lease, as well as for corporate level portfolios. So that was kind of a landscape setting. If we move on to the next slide, we can start talking about our actual solution. So we have kind of designed a bit of a roadmap, really, a kind of phased development where you start from what we see as being the first kind of MVP example of what could be built for this problem area, leading towards kind of the more aspirational kind of further down the road, something that you'd want to kind of move towards. So for phase one, we decided to focus on the kind of pooling or consolidation of these kind of disparate sources of knowledge and pulling them into one place. And the reason we designed this as phase one is kind of, again, for two reasons. One, because in some ways, this is the least technological solution. Some amount of this can be pre-coded and kind of manually done through kind of a sort of flowchart system where you perhaps draw in some of the peripheral context that Fraser was talking about that can affect what provisions are relevant to certain people depending on certain contextual information. So, for example, their age, or whether notices have been sent when they're trying to identify their rights of termination, and these sorts of information, which you could fill in a form, but then follow what could be a kind of pre-coded flowchart to pull in the relevant provisions. So obviously this is a kind of maintenance heavy product, because there are specialist area experts behind the scenes who are designing these flowcharts, identifying this kind of key information, really on the behalf of the user. And obviously, as Fraser said, there are temporal aspects to legislation as well, not just in the changing circumstances of the individual, but legislation itself doesn't always stay the same. And so as it changes moving forwards, as amendments are made, you need to have that team of experts behind the scenes to keep that updated, so that the user wasn't being given kind of outdated advice really on the state of their lease. The other reason this is kind of phase one is because knowing which aspects of the legislation are relevant for a contract is kind of fundamental to all of the analysis that you'd have going forward. And you can't do any further analysis on the kind of health of that lease, without having that kind of base knowledge of what's going to be relevant for that individual. But the product in itself is kind of just pulling that all into one place. So for someone who doesn't know where to look or doesn't know which clauses would be relevant for them, they have a kind of single source of truth, and it still would require them going through it and trying to understand it themselves, which is not a simple thing, but it does create a kind of better starting point for understanding your own contract in kind of its full scope, not just in kind of the limited provisions that will be included in the lease, but the ones that were also carried across from the legislation. So that's kind of our phase 1 for this product. Our phase 2 would be to begin to look at doing that kind of health assessment. Now, this is the kind of service that you kind of hope when you send it off to a trusted loved one, and they kind of give you the A-OK or the run for the hills sign on what the contract says. Not everyone is lucky enough to have someone like that in their life who can understand what the contract really means, and whether or not they should be agreeing to taking on that obligation with a landlord. So the way that we imagine this working was kind of having using NLP to make clause by clause comparisons from what's in the lease and what's in the legislation. So for example, if you can identify, talking about termination clauses, if you can identify which clause of your lease agreement mentions termination, and then the clause in the legislation that's referring to termination, and you can see, for example, that your landlord has said that they only need to give you a day's notice before they can kick you out, whereas the legislation guarantees you more time. You can automatically flag that as a red sign that this is part of the lease is not meeting the standards that the legislation has set out. It's not actually respecting the rights that you have. And there are other examples of places where you can do that kind of clause by clause comparison, even to far as saying things like, well, there's clauses missing that should be in your lease agreement because they are not set out in the legislation, or where the landlord is kind of overstepping on what they've included in the lease, and just giving you a kind of overall view of on balance, how should you be investigating this lease further? Should you be asking more questions of the landlord before you enter into that agreement, as a kind of overall view of the kind of status really of the document. So again, it's not a silver bullet, but it gives you a kind of starting point to kind of say, actually, I do need to be investigating these sections more closely. And these things can be kind of rule-based as well. So you wouldn't need to start using any kind of necessarily any kind of training models to be able to do something like this, because if you have pre-coded what clauses are and what provisions are guaranteed in legislation, what kind of rights that the individual should have, you can also pre-code rules that check things like the number values in the comparative clauses in the tenancy agreement. So for example, that notice period, that's just a matter of comparing the numbers in the identified clauses. So certain amounts of this analysis can be done relatively straightforwardly, even without having like the requirement for huge volumes of example data. So that's why we've kind of put this as a kind of our interim stage for our product. So the phase 3 that we've kind of identified, and by the way, I mean, there's many things that you could do beyond this point. This is just sort of the first 3 stages as we see them. But the kind of aspirational goal for this would be to create a sort of living document. And this sort of stage, we start thinking about making the kind of eliminating the need for the individual, the layman, to become a kind of area expert on lease agreements, so that you could perhaps, and we've kind of envisioned it as perhaps being a sort of chatbot solution where you could interact with a kind of friendly face of the document, ask it questions in natural language, and receive back in understandable terms answers to your questions. So instead of having to comb through the agreement and looking for things like notice periods and then seeing how it compares in the legislation and is that red flagged or is that green flagged, you could just ask the chatbot, what is my notice? If I was to sign this agreement, what would my notice period be before I'd be kicked out by my landlord? And the chatbot could then say to you or communicate to you, well, your lease says this, but actually in legislation, you're guaranteed this. So maybe you should talk to your landlord about it and kind of work it out with them. Just a kind of more interactive and less, on the part of the individual, less labor intensive process for understanding your lease agreement. And again, there are kind of layers of complication that you could have to this. So if you were to have a preset questions that you were expecting a user to have, that would require less kind of technical investment into the product, because again, there's a certain amount of pre-coding you can do when you know what questions are going to be asked. You can from the team that are maintaining the solution or building the solution, your machine learning model team, the training data is easier to create because you can be very specific about what you need, and you can kind of preload it with the training data necessary to identify how to answer these types of expected questions. So for FAQs, for example, it's very similar to what they do. They have a kind of preset questions that they expect you to ask, and normally in a traditional FAQ, obviously a human's written out the answer, but it's not much of a leap to go from having those preset questions to being able to find those answers in the document. A kind of more advanced example, or a more advanced solution for this would be something where you could ask your own natural language questions, not needing to pre-select them from a list. Obviously, this gets more complicated because you need to start thinking about how questions will be asked, what language are the users likely to use, what parts of their question kind of indicate emphasis on what information that they want. It just becomes a more complicated process, but that would perhaps be let's call it a phase 3 part B, where you start bringing in more natural language and conversational solutions. So that's kind of our roadmap, and I'm going to hand across now to Chi, who's been looking at the models that exist already, that kind of give a bit of a signal that there is legs to this kind of solution.
Okay, thank you very much, Ray. So as mentioned previously, our goal is simply put twofold. One is to see the conformity between contracts and the legislation, and we can also flag risks where possible. But now the question is whether we can detect the similarities between contracts and the lease. And the second goal is that could we have a vivid or interactive chatbot to answer those questions asked by human beings in a natural way? And it is not something like you type in keywords and it is done by comparison. No, it is just find the answers naturally and give you the answers naturally. So, okay, so next slide, please. So first one, the feature one, dot comparison. So our task is to compare the contract with the law, right? So the data include, first of all, the sample lease contract clauses, and the second is Renting Home Wills Act 2016. We have already found several pre-trained machine learning models, and we have selected one of them because the model was trained and fine-tuned in a very large sentence pairs data set. So if we can try to put the lease contract clauses in that machine learning model and see the comparisons, it will tell us a little bit about the capacity or what we can do so far. So, okay, next slide, please. Let's phrase our next slide, please. Okay, thank you. So let me do this little demo for you. First of all, okay, thanks. So the first one is one clause selected from the Wells Act, which is 152. It is selected randomly, not on purpose. We just want to see the capability of the machine learning model. So we also selected 3 sentences here. You can see the first 2 are random contract clauses from copy paste from a lease contract, and the third one is just a random sentence that I drafted. So one click, please. When we put these sentences inside the machine learning model, it will give us the results. As you can see, the machine understand, or let's say conducted the matching process and tells us that the first one compares to the law with a high or relatively high confidence rates. From our point of view, the machine did a good work by compare the law with the contracts and tell us the similarities there. So on the next steps, we will keep training the machine learning model with the actual laws and regulations and even court cases to give the machine more information to learn with. And I'm very positive that this pre-trained model will give us a very positive outcome. Okay, let's look at the second feature, which is a chatbot. So as you can see, the task is, and we need to have an interactive chatbot to answer questions in a natural way, right? So the data is the same, and we use another pre-trained machine learning model. This is also a very popular model, has been downloaded, I don't know, probably 1 billion or more times. So let's see the results. One click, please. Yeah, so we also selected the law 152, and we have a question there. Instead of asking some keywords or instead of typing in keywords, we can simply ask some question naturally, like, can I end the contract early? Because that clause is about, that provision inside the law is about the early termination. So if I were a tenant, I would be very interested in asking when can I end a contract and can I end a contract early? So let's see the outcome. One click, please. Okay. As you can see, I inserted the law inside the context block, and I asked the question, can I end the contract early? And I click on the compute button. The result is the contract holder may end the occupation contracts at any time before and earlier. At this moment, we can see that, okay, on one hand, the machine is trying to find the right answer. As you can see, at the 152, the early termination by contract holder. So contract holder may end the occupation contract at any time before the earlier of A and B, A or B, right? But the machine couldn't understand the logic of A or B. It just gives us the results of at any time before the earlier. I think that's a very good analysis by now. We just need to train the machine with the right document, because by the time that I insert the context, the machine hasn't been trained, hasn't been fed with any information like Welsh law or anything like that. So the only thing we need to do in the future is to train the machine with the correct information. And I'm sure that the machine will give us a more accurate outcome. So yeah, this is my parts regarding a demo. Of course, there could be some challenges or limitations So let us welcome Fraser to tell a little bit about the limitations, and I'll also add my input as well. Thanks.
Yeah, so challenges, and I see we've got one typed question as well, which I'll maybe try and loop in at this point as well, but obviously more questions welcome. So kind of three big challenges as we see it really at this point. And in a sense, the first two really just replicate the challenges that make this stuff difficult for anyone, that is the reason that you would have to go and seek legal advice, which is this is complicated and things are a bit dynamic. So one of the challenges is fact pattern changes. As I mentioned, even once you've established what your lease is on day one, changes in circumstance, tenants coming in, tenants leaving, the ages of those tenants changing, can have a bearing on rights and obligations. The lease could be assigned to a different landlord. Again, that could alter the analysis. So the system, if in phase 1.1, we're almost thinking about just being able to take a lease at a moment in time, maybe a phase 1.2 almost is being able to record some of that data and store it in the system, so that when it detects a fact pattern change, it knows your birthday and it knows you're now 18, for example, so now you've got an occupation contract. It could kind of handle that, and of course that complicates things with data protection and other matters. The other kind of thing that can change is the law, the background law. As we mentioned, there's potential at least for regulations and indeed other statutes to come along and change things. Processing all that might be quite complicated. And as Ray said, initially at least what you're looking at is quite a lot of experts behind the scenes, pulling the wires behind the Wizard of Oz's curtain to kind of spit these things out. And if the law changes, it might require quite a lot of reworking of the flowcharts and the models that all of this operates on, which, in terms of scalability for a jurisdiction the size of Wales, how much cost relative to the cost of citizens advice bureaus and lawyers and individuals doing this, what's the break-even point where this actually becomes worth doing as an automated service? Is there a wider market here potentially? I mean, I happen to know because I drafted it. The Scottish tenancies, private residential tenancies law is not dissimilar and has similar features. So perhaps, by finding other jurisdictions or by finding other contract types, there's a way of scaling this up to make the development effort more worthwhile. As for the challenges of I'll just briefly touch on James's question in the chat. So James was asking about, wouldn't you need standardized contracts for the automated functions to work? I think the answer to that is the Welsh law, the law in all parts of the UK, as far as I know, have not gone as far as saying you can only contract in these terms. We did toy with it in policy terms in the Scottish government, and for various reasons, it's too problematic kind of to impinge on people's freedom to contract to that extent. Second part of James's question, he raises this point about a tenancy agreement builder. We have that in Scotland as well. As I see, there's the Rent Smart Wales service, which will kind of look at the law and generate a kind of model contract. And I see that the Renting Homes Wales Act allows the Welsh government to publish model lease agreements. So for the landlord, I guess those tools are out there already. If they just want to generate a standard model contract and know they've complied with the law, there is tooling out there for landlords to do it. I guess our problem, our kind of target user is the tenant, who's the recipient of this agreement. And maybe these model contracts provide a good basis for the text comparison, but we're more interested in what happens when your landlord gives you something that's not the model. or diverges subtly from the model in different ways, and how can you as the tenant have confidence, short of just going through it and saying that's not the model. And if they say, well, no, it's not, where do you go with that? But I'll hand over to Chi for the kind of technical difficulty side of it, because it's all space magic to me.
Thanks. I just want to say that it looks like our demo is very promising, huh? But there are some questions or limitations or challenges that we have been facing or we have been dealing with. One of them is the explainability of the results. There are two things inside the explainability problem. One is even the developers, or let's say the law experts, they don't seem to understand the results or predictions made by the machine. On the page that I presented, we can only see numbers of accuracy or confident rates that the machine has given us, but we don't know why the machine has made the decision or the machine has made the prediction. So the difficulties here are, first, we need to understand how the machine really do the analysis, and second, how we can present or showcase the analysis to end users. Because in the context of renting homes, a lot of end users don't understand law, they don't understand technologies as well. So the thing is, we need to present or showcase or demonstrate that the machine is making the prediction based on key elements A, B, C, D, and how can we do that is a challenge, I would say. So in the foreseeable future, we would like to incorporate or include human beings in the loop. So in the beginning of training the machine learning model, we need to have legal experts on board. And then during the whole process of training the machine and let's say retrain or do the data cleansing, we need the human experts to be involved. We would really like to take questions.
Thank you. I do have a couple questions that I've been writing out as we've been going through this. So the first question I wanted to ask was concerning, so you're using a natural language processor to run your chatbot essentially, or at least that's the proposed solution to identify these things. But obviously the people who are looking for answers are looking for de facto answers, not confidence answers, if that makes sense. Like if I want to know if I want to terminate a contract, I don't want to know if I have a 70% chance or 0.7 confidence that I can do so. I want a de facto yes or no. So how do you reconcile that element of using an AI to do that?
The confidence readings are more something for the background of the ML engineers who are designing the solution. So from our perspective, I mean, for the first thing to say is that in any kind of chatbot solution, you have to have a kind of disclaimer whereby there has been understanding that when you're providing any kind of legal advice, the person who's accepting the legal advice from an unauthorized source, so for example from a non-legal law firm or whatever, that you are taking on a certain amount of personal responsibility for whatever advice you receive, whether or not you follow that advice. So that's kind of the first and the sort of disclaimer aspect. The aspect of the confidence, I mean, you use the confidence scores in the background to determine whether or not your model is a suitable solution. So when you have predetermined questions, so for example, you know what sort of questions they're going to ask, that's easier to do because you can say for this type of question, we always get a 0.95% accuracy. So it's almost always 100% accurate. You can never guarantee, obviously, 100% accuracy. If you're allowing natural language questions, so variable questions, obviously that becomes much harder to optimize because you don't know what questions are going to be asked. You can't guarantee across every type of question. However, you can still, from a solution perspective, flag uncertainty and be able to provide that as a sort of, almost as part of the disclaimer, saying this is what we believe it to say, but we're not positive on this answer. So, please consult, please read through this part of the contract. You can still flag that up without it being a sort of getting into the technical nitty-gritty of confidence levels. I don't know if that answers.
Yeah, sorry, yes, go ahead.
I was going to throw in one more. I mean, not to be too good at kind of glib about the state of my own profession, but even when a lawyer does give you an answer, there's a certain confidence bar of error involved in that. I mean, one of the things we've seen, certainly in the Scottish tribunal cases, since we brought in very similar legislation, is, quite a surprising number of cases have to go to appeal because even people with legal advice have failed to correctly understand what type of lease they have, what the position is, so yeah, I mean, I suppose the point is there's always a margin of error in answering any legal question. The law isn't really binaries and certainties, and that's often one of the difficulties with law's core initiatives, is that computers want 0 or 1.
Yes, thank you. Okay, yeah, that definitely answers that question. So I did have a further question with regards to, obviously we're dealing with Welsh law. So if you may be provided a contract that is in the Welsh language or one that is in English, would you be using separate chatbots to interpret the 2 different languages if I say I only had a Welsh contract?
There's certainly a complication. In fact, when we were doing the market research, one of the aspects we were looking at, one of the dimensions, was what languages are supported by these different applications. And it's not an easy thing to generalize any kind of natural language solution to work across languages. And in fact, trying to train one model on 2 different languages, I think you'd find you'd have very little to no success. So you would end up in some ways having parallel systems, but in some ways, never minding the sourcing of the language data, if you're just talking about the actual engineering aspects. In general, the model that you create, the pipeline that you write for your machine learning model doesn't typically vary depending on how generalized the model is. If it's a rule-based one, then it can vary a lot depending on the rules of the language. But if it's a very generalized solution, the pipeline, which is the difficult bit to craft, doesn't necessarily need to change. It's just the training data that you feed in. And of course, the more languages that you support, the more difficult that maintenance cycle becomes, because if you're having to keep on top of changing legislation, you're going to need to keep feeding in the updating training data in the different languages. But from an engineering perspective, it's not any more complex, particularly to maintain parallel systems. It's just, the volume of data and the maintenance.
Okay, I did have one last one. So this was concerning, obviously you get the contracts typically in various different forms. So some providers will give you this through something like DocuSign, which you'll be able to export as a PDF. Some people hand you a physical contract. What considerations have you made with regards to getting the data into the system, with regards to these different file types of potentially being a Word doc, a scan of like a physical image of a physical contract, and dealing with potential artifacts or PDFs that you find online? What considerations have been made around that aspect of it?
I'm going to keep hogging all of the answers. If anyone of my team wants to interrupt me, please feel free. I won't be offended. But I have put some thought into this. So for any kind of system like this, when you are anticipating a number of different potential formats, there are like kind of out of the box solutions that you can use. So for example, there does already exist even plugins and libraries that you can just, plug and play into your application that do things like take a scan of data and match it to letters. Obviously, if it's a handwritten document, which is very unlikely, but if for some reason you did get a handwritten document, which first of all I think should already be flagged up as a bit of a red sign, but if you did, that can be a bit more complicated. But generally printouts of printed words like from a word processor are very easy to scan in, and again probably a bit suspicious if you're being sent that by your landlord, but you must anticipate that perhaps your user would be handed a printed document. But that sort of thing is a well solved problem, as is converting between PDFs to Word docs. The only thing that normally gets in the way is formatting tends to go a bit awry when you convert, for example, between a PDF and a Word document. So that can depend on how you're doing the sentence by sentence comparison. If you're relying on formatting, or if you're relying on metadata, which obviously changes between formats, that could be a huge problem between the different types. But in general, if you're just pulling out the text and treating it on a sentence by sentence basis, you can just use kind of out of the box solutions to handle that.
All right, no further from me.
I had a couple of questions, if that's okay. So the first one is, so the bots are going to get, you know, either preset questions or natural language questions, and then they're going to sort of try and provide answers based on the legislation itself. And I was just thinking, and no offense to Fraser and his colleagues, but you're going to run into the fact that legislation is not written in natural language, and quite often you may land on a section that like basically opens up a rabbit warren of, right, I need to look at this section over here, and I now need to look at this section over here and this other act over there. And I was just wondering how you would cope with the fact that like the key piece of legislation, the key provision you might want to land on, doesn't tell the whole story in an easy to understand way.
Yeah, I think that's partly where this becomes, you know, quite expert driven behind the scenes, that we probably wouldn't, I mean, unless everyone else has some genius technical solution to this, we probably wouldn't, for the purposes of producing the legislative standard that the comparisons being effected against, simply rely on the text of the statute. We might need to interpolate into it, you know, the definitions and the other things that hinge off it in a way that wouldn't be totally obvious to machine. And an obvious example is all of your termination notices have to be sent. I think the word is given in the Act. And of course, given is defined quite carefully as to the modes by which you can give things. That in turn will then plug into the Interpretation Act, which will provide further kind of clarifications. So all of that would need to be kind of built into a representation of the legislation, which isn't actually the pure text of the legislation, but is broader and contains that whole package of stuff.
So you'll need basically an editorial function in the background, sort of refining some of these answers.
Yeah, I think basically quite legally intensive. I mean, again, it just comes back to, you would need somebody doing the job that an actual lawyer would do. The hope would be that once they've done that job once or twice, and you've encoded that into the system, that person doesn't need to keep doing the job. But yeah. And
my second question was, and I think you kind of touched on one of your previous answers, Fraser, is how you take into account case law. Obviously, in the area of contracts generally, there's an awful lot of case law knocking around, and decisions made on fairly, reasonably recent legislation like this. There'll probably still be cases coming through. And is that something that, again, that expertise would be having to keep an eye on?
I think it would be the same answer if the case law came to a really kind of unusual explanation of what a word in the statute meant, for example. Then the corpus, the kind of technical representation of the legislation in the background might need to be updated to reflect that. I mean, from what I've seen of tenancy cases so far, I mean, that's the exception. Most of them are pretty straightforward factual disputes. They're not kind of matters of high policy that get to the Supreme Court that often, at least not, if they are, there's sort of human rights dimensions and things that are just not going to be machine processable. And I guess part of the aspiration here is that at the very least, the system is flagging up areas where you might want to go and seek further legal advice, or tell you if there's a bit of a point here. But yeah, I mean, case law is difficult. I look forward to it.
I'm thinking just in terms of if this tool is like to give people, alert people to risk, it's like, this is the sort of thing that goes to court a lot, is quite a good thing to know, I suppose. But anyway, obviously that's, you've had a week to do this, so I'm probably looking too far in the future, but just that's a thing probably to bear in mind.